firstly, clubs have a principled obligation both to the victims making accusations against players and to the rest of the club to accuse that person and stand them down with full pay. Secondly, they have generate a harm to the fairness of the trial when they attempt to do discretion in whatever metric that they choose, and discourse around which crimes are serious and which are not, all of which is deleterious. Let's start with the principle. I think this has two parts. The first is about the duty to protect victims and to believe victims, which refers to basically in circumstances of uncertainty about whether or not someone has in fact committed a crime. It is by far the best principle to assume that if they have received, they are being charged for a crime, that it is probable that they have committed it, that they are guilty, and to err on the side of having that person stood down from their current duties. And best to, signal quite publicly that you believe the victim, that you believe the accusation is at least fundamentally serious enough to be treated outside of your own discretion and indeed by a legal court. And the reasons that I will give to ground this, intuition that we have are fourfold. The first is it is an extraordinary sink of your money and time to make an accusation in general of quite serious nature, but also probably toward, this is exacerbated when you consider this is probably a high-profile sports player, loved within the community, that is probably fairly foreseeably something that will, raise the costs, raise the impact on your time quite a lot. But secondly, you would see that, especially in these kinds of cases where there are high-profile sports players, there is an incentive to attack the victim. People are unable to, at least in the initial cases, believe that someone that they love quite a lot is capable of a really serious crime like sexual assault or like drunken violence against another person. And so they discredit the victim, they attack them, they generate furor, and most people foresee that as likely if they come forward with a public accusation against a sports player, which means that it's probable that that person has considered that at the point where they are going to report the crime, and they're probably taking that pretty seriously. Thirdly, even if it's not true that you're have a lot of trauma associated with the crime that's been visited upon you by that person, it's often unpleasant to interact with the justice system. Police have to interrogate you in a way that kind of implies that they don't believe you. Cross-examination is well publicly regarded to be an incredibly intense process for someone to go through, all of which explains why you'd probably only opt into reporting it if you had a really serious conviction that the crime done to you was serious and was true. Fourthly, it's difficult to sustain a lie, especially in the case where you face so much media scrutiny for the lie you're potentially telling, and there are rules like perjury that prevent you from doing so. All of which explain why, when a victim comes forward with an allegation, when it gets taken seriously by the legal system, when that crime has been charged, that person is, on the balance of probabilities, probably guilty, which explains why clubs have a duty to believe that victim and to take some action and to protect their welfare, to signal that they take that crime seriously. But secondly, clubs have a duty just to themselves, both in the sense of the players who constitute that club, but also the reputation and values of that club generally, to have that duty being discharged by standing that person down. And the most obvious iteration of this is the kinds of crimes we're talking about generally are pretty serious. They are violent, they are sexual assault, they are committing, in some cases where homophobia or hate speech is a crime. It is serious things that compromise people's welfare. And it's reasonable for a club to believe that someone who's done that may do it again, that they may not currently feel remorse for it, and especially if that, they receive discretion, they don't actually get stood down from their job, it seems pretty probable that, they're quite emboldened that they're, not really facing any consequences, which means that you have a duty as a club to consider that crimes of violence, sexual assault, etc., could be visited upon the other players of that club. And, in sport, it's often pretty violent, there's a lot of contact. That seems like something that seems pretty plausible. Clubs should have a duty of care to their players and an obligation to defend them and consider their welfare and take people who could be potentially dangerous to them away from those circumstances. But also, we reckon it's just a pretty, uncontroversial contractual obligation that clubs, especially sports clubs, which often have a lot riding on their reputation, on their sponsorships, on how they're perceived externally, who have people who sign contracts, quite a lot of money, and have then breached them by breaching the rules and values of those contracts to stand those people down. I reckon they probably should do that. They should probably follow their obligations that they have to that club and to its values and stand that person down. All right, let's get into the harms of discretion. The first is this creates a preemptive judgment that bears on the results of a trial. So there are many ways that clubs could use their discretion to try and make good choices. one of which may be they try to evaluate the evidence for the crime being committed, and try to say, oh well, if that person, we don't believe that evidence is really credible, so we're not actually going to send that person down. And the perception harms here, I would think, are pretty enormous. Like, if that person ends up being guilty and they were actually found by the club to not be guilty and not stood down, then I reckon that prospectively going into the trial, where there's a lot of media coverage about that club's decision, jurors potentially are able to see that evidence, the court of public opinion bears pretty heavily on the results of trials, which means it's relatively less time that they're actually found guilty. But also, even if they are found guilty, that eventually is discredited in a way that I think is deleterious to those victims feeling a sense of justice, and to that harm actually being repaired, which I think is bad. But also, if they're not guilty, the opposite effect is true. I think it's true that if that person isn't guilty, that person experiences a harm by being evaluated as guilty, and having it seem that their club decided that they were guilty on the balance of evidence rather than just as a matter of course, which is probably bad for that person's long-term reputation, which we think is bad. Secondly, this creates a media furor because if they try to make an evaluation, I reckon there's a lot of attention that it is before they make their evaluation about whether or not they're going to stand that person down, about whether or not they're going to do it. So there's going to be intense scrutiny on that process, which will heighten the media attention around that crime, which is deleterious probably actually both for the victim and the accused, because it makes all of the, trials really struggle when they are covered in the media to get fair juries who haven't been polluted by what has been said about those trials in media. And when there are evaluations about guilt and not guilt that have already been made by the club itself, that makes it a lot harder for those processes to be fair. But it also means that there's a lot of attacks that happen on, that aren't necessarily that evidence-based, that don't meet legal standards on the victims and on the accused, all of which is pretty harmful to them, I would suggest. When it's just a matter of course that if someone is accused of a crime, they are stood down, there is less media attention, there's specifically less media attention and coverage about whether or not that person is guilty in the opinion of a club, all of which means that people are able to come to better evaluations about whether that person is in fact guilty. But secondly, we think it creates adverse norms about what crimes are actually taken seriously. So one other metric that clubs could use to stand down a player might be standing them down for relatively serious crimes like violence or sexual assault, but maybe, for instance, if they get into a brawl at a pub, being like, oh, well, that's not as serious of a crime, that's part and parcel of being a sports player, so we won't stand them down, which creates a normative judgment about which crimes are actually bad and which are not, which crimes are worth punishing and which are not, which we think is bad because crimes by judgment of society have been decided as things that harm either someone or society generally, and you shouldn't normatively chill conversations about, for instance, is punching someone in the head at the club a bad thing to do? We think that is bad and we shouldn't do that. But also, it leads to subjective evaluations. For instance, is that player popular? Is that player important to the club? Being considered quite heavily, which affects whether or not people ultimately go on to feel like that person has committed a crime, which we think is exceptionally unjust and is a perversion of justice. For that reason,
just very quickly, some rebuttal to the opposition. I think, importantly, they tell you that there's a principal obligation that exists to victims. The clubs somehow are intertwined with this principal obligation. It's admittedly somewhat unclear exactly why this obligation exists for clubs and why this is not an obligation that perhaps exists exclusively for governmental institutions or other institutions of society that are specifically designed with this purpose in mind. And it's kind of unclear why you have adversarial systems in particular. And I would just admit, I'm assuming we're talking primarily, if not extensively, about adversarial systems as opposed to inquisitorial. Opposition didn't deal with this. I'm just going to safely assume that it's adversarial. If not, on the second can reply, and maybe, magnet material. Regardless, on the question of adversarial systems, there are specific institutions designed to protect the rights and interests of victims. There are specific institutions designed to advocate as extensively as possible for a conviction, to seek out justice, to seek out a conviction, more or less at all costs, perhaps barring the cost of justice as an institution insofar as you could define it, right? I think that it's important to understand that maybe the obligation to victims that they tell you needs to be considered. It does not go unfulfilled. There is already that principal obligation. if that principal obligation applies to other institutions that already exist under the status quo without this blanket ban. And I know that those institutions are particularly more qualified, more experienced, and more capable of advocating and more capable of achieving that principal obligation than perhaps a sports club is. I think it's somewhat like I think it's somewhat ambitious to expect any sports club or sports clubs as like a community or as a group of institutions to be able to fulfill this obligation in any meaningful form. Because at the end of the day, if all they're doing is enacting a blanket ban that is like written into their policy and it enjoys no scrutiny or no discrimination, no discretion, at the point in which they're just enacting a blanket policy, I would say they're probably not advocating for the rights of victims. They're probably not fulfilling the obligations that exist for victims. They're probably just, as the opposition, kind of intertwined at the end of their speech, just advocating for themselves and their own interests. And at the point in which those do converge, maybe there's an argument to be made that people should be stood down. And I think that is an important part to be considered when you have discretion, as you have under either side of the house. What does this largely mean? Okay, on the question of victims, I think I've largely told you the principle clutch there is somewhat underproven. But on the question of practically what does this get about for victims, I think in a particularly Western, in all legal systems, there's an importance, and perhaps in all elements of society, there's an importance that should be placed upon making evidence-based decisions. I think it's far more valuable at the point at which an institution or an individual, whoever is making a decision, should probably be doing so based on the amount of evidence that they have available to them. To ask them to make a decision that is based, that was preordained, that was predetermined, without any insight, without any foresight as to the evidence that exists at the time, without any foresight or insight into the circumstances that exist, I think is rather foolish. I think that a blanket ban largely just does not work, because at the point at which you do not achieve the right outcomes for the parties involved with the evidence that you have, you are probably going to begrudge all the parties involved in that system. I think at the point at which this happens once is a miscarriage of justice. I think at the point at which it happens endemically, and you begin to get more and more begrudging players, begrudging fans, begrudging all the stakeholders that are involved in this voting process, in this process at all, will be more and more begrudging at the point at which you enact this blanket ban. I think this is only a bad outcome for sports clubs. I think this is only a bad outcome for all the stakeholders involved, for players and for victims themselves. On the question of there's also just a question here about evidence-based decision-making, who has the best faculties to make these decisions. I think sports clubs, at the point at which you are the employer, and in so many ways, far more intimately involved with your employees than other employers are in other industries that are not sports, right? At the point at which you're a sports club, you probably have access to far more information, far more evidence to be able to make an informed decision that would, go unsaid in any other industry. And I think it's important to remember that there is no burden on sports clubs to release all the evidence that they have. There's no burden on sports clubs under the status quo or under Oxworld to, be exceptionally flippant about advocating for their employees. But at the point at which they are willing to do so, if they believe there is a strong case for them to advocate for the employees' innocence, or at least the presumption of their employees' innocence, at the point at which they believe that is a sound decision to make for their business case, there's no reason to prohibit them from doing so. At the point at which they decided that is a sound business decision, at the point at which they decided that this preserves their interests and that preserves the interests of their stakeholders, I think this is perfectly reasonable, and it's probably more likely than not that any club who chooses not to stand down a player charged with a serious criminal offence, which I know goes undefined, any club who chooses to stand down that player is probably doing so with all of the rationale that the opposition thinks is important, with the obligation to victims if that club believes it even exists, which they haven't really proven exists for that club. But supposing it did, right, they're probably going to incorporate that decision making. They're going to incorporate the business case. How profitable is this? How will it reflect on the sport going forward? How will it reflect on winnings? How will it reflect on the gambling side of sports and whatever? And more importantly, how will it reflect on public reputation and perception with fans and what have you? I think this is far more important and more compelling case for a sports club to be able to make that decision with all of those factors informed than for a sports club to be flippantly, to be totally with its hands tied behind its back, to be able to just be forced to blanket ban all of its players accused of serious criminal charges, right? On the question, I think why this is particularly important, I think this leads into the underlier of our whole side. It's probably going to be something about the cost to the clubs, the cost to the players, the cost to the sports, and the cost to fans of these sports, to all the stakeholders involved in the sports industry, right? So firstly, there's a huge financial pressure. If you expect a club to just continually just pay out someone who they've had to stand down and cannot reap any employment, the transaction of employment is not being fulfilled in that case. You're just paying someone because you have to stand them down because of a policy that was written in, to your contract. That's pretty unreasonable to expect fact they can't do that for financial reasons. It's pretty unreasonable to also expect any clubs to, be able to gain confident backers in the future based on that, because the decision of when a player is prosecuted is entirely out of the control of the hands of the club or the managers or anyone involved with the stakeholders of the first instance. I think it's entirely in the hands of third-party institutions. On the question of particularly when victims are particularly sympathetic, right? I think that it's probably a compelling reason when you have a sympathetic victim who is in the public limelight to be it may be the case that in the case of discretion the club still chooses to stand that player down, and in fact they may do so without pay, which for all the reasons that opposition tells you is important to the reputation of the club, it's even more important that they have the opportunity to do so without pay, the opportunity to do so with more conditions, than to merely be tied behind their backs and to say they have only one option, and that is to stand them down with pay. I think that if you had a case in which there was a particularly sympathetic victim, and if you had the case in which they described you as the extreme, or I think they tried to characterize it as particularly likely that a victim is particularly sympathetic and it's particularly harmful to your reputation, they tried to characterize that to you as particularly likely in that instance you're better off on the outside because you have the discretion to not have to pay, right? So there's also a potential cost here of civil liabilities in the future. I think that this goes, largely I think largely opposition perhaps forgets to mention that you open up your club to a significant amount of civil liabilities in the future, and probably you open up the class of sports clubs to civil liabilities at the point at which they are forced to stand you down, well, not forced, they opt to stand you down without pay in their policies, regardless of whether or not the evidence against you is particularly compelling. I also note that there are jurisdictional issues here, right? So we're talking about, opposition wants to say we're talking about largely, by and large, high-profile sporting athletes. I think often these athletes travel internationally, they bounce between jurisdictions. What is a serious crime in one is not what is a serious crime in another. I think it's unlikely to expect the sports club to be able to make that determination on every case basis. So if you just accept what the jurisdictional relevance is for a serious crime, I think at that point you hit yourself, because what is a serious crime in Indonesia is not what is a serious crime in Australia. Thanks, Speaker.
About two things in the speech. Firstly, I want to talk about victims, and then secondly, I'll talk about clubs. Before I start explaining why I think on a comparative level this is always better for victims in the long run, I want to explain why you should, at the foremost of this debate, prioritize the way to impact victims. Firstly, I think they are most clearly the most vulnerable stakeholder, and I don't mean that in the way that they say people are vulnerable and therefore should care about them. I mean mistrials or effects on victims, or the way that victims are discussed in media leads to people committing suicide, leads to people having long-term serious traumatic experiences that harm their lives. It leads to people who have serious trauma associated with really significant events going on and affecting them for decades, not just for months, not just for weeks, in the way that it impacts the player that is falsely accused, or the way that it impacts the club. But secondly, we're talking about a huge disparate level of vulnerability here. We're talking about clubs that have millions of dollars worth of funding, often tens of millions or hundreds of millions of dollars worth of funding in many cases. We're talking about players who have salaries that are tens of millions of dollars a year, huge social safety nets to fall on, millions of fans who will protect them and insulate them, even when they are found guilty of serious crimes. This is a clear and cut case where the priority of governments and priority of clubs should be on protecting victims. And that is the way that governments make policies in almost every instance. We do not permit companies to do whatever they want in every instance when it has negative externalities on society, because the government has an obligation in those instances to step in and protect power imbalances. We recognise that the government has huge impact over people's lives, and that impact is greatest in those with the least power. Which is why the government has a principled obligation to step in where there are imbalances of power. Democracy and fairness is not just important in elections, it's also important when people are unable to exercise their freedoms in their everyday life because of the injustices that exist in society. Governments have an obligation to step in and change outcomes where they can. So firstly, I'm going to explain what we think on a comparative level this is good for victims. One thing I want to point out here is that whilst the team is correct in that attention on serious crimes can in some instances be good, and we should have sympathy towards victims, not all levels of attention are good, and certainly not all kinds of attention are good. What do we mean by that? I think firstly, we point out that it is extremely harmful for the public media to focus on aggressively litigating the seriousness and validity of allegations. Why does it happen more than cite negative? when it is a consideration of whether or not you should stand down a player, if that allegation is serious, if that victim is sympathetic, as this team labels them, if that victim is accusing someone of a serious crime or a less serious crime, that creates incentives for both sides to lobby that club through the media to believe one thing or another about that allegation in order to get their desired outcome. That leads to three important harms that I think this team does not respond to at any point in their case. Firstly, it has a really bad normative impact on how allegations are perceived by the public, because it normalizes delegitimizing specific allegations against people. It normalizes high-profile figures saying that this person is less credible for reasons that we think are fairly frequently unjust. Things like that person is a person of colour, that person is poorer, that person is more privileged, are all more likely to lead to that person's allegation being taken far less seriously than others. That is harmful to the way that we in general perceive allegations coming forward. And that informs not just the way that we take high-profile allegations, but also informs the way the general public perceives allegations in their everyday life. It means when they hear about their friends being accused, they are more likely to believe it is reasonable to interrogate that person who has accused their friend, to not believe them, to socially protect and insulate that person from harm, because they see in the media high-profile people that they respect and care about and believe the voices of, defending the people who are accused of serious crimes and delegitimizing the allegations against them. Secondly, the observer has a really bad normative impact on what misconduct is and how misconduct is perceived, because again, it differentiates between some crimes which are serious enough that clubs should take action and use that discretion to act on, and other crimes which are less serious. It means when a player is accused of sexually assaulting someone, they get stood down. When a player is accused of groping a woman in a club, that player is not stood down, and you can see that being part of the course of being a sports player in a way that is incredibly unjust and bad for the way that those crimes are perceived in the long run by other people, which again has impact not just on high-profile cases, but also on people's everyday life. Because when they see their mate doing that behaviour, they think it is not sufficient that they should take action, because their club didn't take action when it happened to their favourite sports player. But thirdly, we point out it has a really big harm on the victim themselves. This means they have to sit through all that discourse occurring about their trauma in the public. That is one set of harms. Secondly, I also think this leads to a much better, we point out that it is much better if the brunt of this discourse occurs post-trial. That is, firstly, because in many instances, social movements go all in on this person and then they end up being innocent. That is a huge harm. Firstly, because it's bad for the victim where it's occurred, because they get more death threats levied against them if this has occurred unjustly via discretion. But secondly, it makes social movements look far more villainous and just. But secondly, it's also that large public attention pre-trial leads to corruption of that trial process. To the extent this team is willing to defend people who are accused, who say they deserve a fair trial as well, having extensive litigation in the media around the validity of that crime and the evidence involved leads to more mistrials. It leads to more bias amongst jurors around what they perceive about the seriousness of that crime is bad. But thirdly, we just observed that less trigger points for outrage are better. The more question marks that are involved in whether or not an action was responded to appropriately, the more likely you get shock jockeys jumping onto that issue, spreading more information about that crime in a way that is harmful. And that is bad for the victim, it's bad for the person who is accused, and it's bad for the club. Because whilst we should take these allegations seriously, it is bad when we take them to the point where we are now sensationalizing those problems, injecting misinformation into them, and discussing them in a way that is discursively harmful. All of that should explain to you that on net, we get far better treatment of victims, far better treatment of these social issues. Even if this team is able to prove its principle to a maximalist extent, and you believe that clubs have a right to this discretion, that right conflicts with the series of rights I've just observed. The right for people to not be groped, the right for people to not be sexually assaulted, the right for people to receive fair trials are equally important, and where rights conflict, you need to make a trade-off between the two. We explain a series of reasons why you should prioritize a set of rights that we harm. Next then, I want to engage charitably with this team's materials and clubs and why we should defend them, to explain why even if you believe they're the most important group in this debate, you should still hand this debate to us. The first claim they make is that sports clubs are well positioned and we have no reason to prohibit them from using this discretion. Three reasons I think why clubs on net are more likely to make this decision badly than well. Firstly, they obviously don't have access to the vast majority of evidence involved, which is to say, for the purpose of ensuring the security of the trial, that evidence is often not released to the public. Clubs are not allowed direct contact with the victim. They can't interrogate them or just discover whether or not that person's actual description of what occurred seems legitimate or not. They're often prohibited even from talking to the person who's accused because that person is gagged from speaking out in the public about the kinds of things that occurred, the specifics of the trial process, which means they're acting on little evidence and rather superficial things. But secondly, we also think they're subject to a series of extremely unjust incentives. Those are threefold. Firstly, they have a profit motivation towards keeping that person on the field, especially if that player is popular, which means they prioritize some players over others in a way that's arbitrary and unfair. Secondly, they have loyalty towards that player, which means they have an artificial bias towards that player. And thirdly, they care about optics in a way that is harmful and using that discretion badly. As this team points out, where the victim seems sympathetic, they might be willing on their side to never define what sympathetic is, and I think there's a clear set of reasons why they would define sympathetic quite poorly based on other social biases that exist. But thirdly, I think we can prove that rarely these clubs are sensible actors, even if they have access to information. They often have long-standing cultures of committing violence, built from a self-incentive to protect themselves and their own reputation, decades of where society and then permitted violence to occur within those clubs. We have empirical evidence to support this, but also structurally it's clear why those outcomes occur. It is in the interest of club owners to be permissive of violence, to be permissive of sexual assault. They often themselves have accusations against them, but it's also protecting their club's reputation. Their next claim is that they open them to civil liabilities. I would point out firstly, this is not true. To sue someone in a civil court, you need to prove a cost. So if you maintain their pay, you can't sue them for any damages. But secondly, it's obviously much worse when you have discretion, because now you can claim that that due process of that discretion was unfair. And the mechanisms I provided for why clubs make decisions poorly also explains why they would be open to more civil liability in the instance where you give them the power to use that discretion. Very proud to affirm.
Note the negative team's lack of clarity on the roles and responsibilities of the clubs in their case. On the one hand, they claim that clubs should decline to take responsibility for protecting the welfare of alleged victims. But then in the next breath, they position clubs as rational, legitimate, evidence-based decision makers who should be compelled to engage in essentially a fact-finding mission to resolve issues the player is involved. We on Side Affirmative, I think, take a far more reasonable route, which is to say that clubs' role is to take allegations seriously, but not to be the final arbiters of the players' guilt or of the severity of their offences. 3 parts to this speech. Firstly on players, then on victims, then on clubs. Firstly on players, I'm going to start here and engage charitably, assuming that victims are not the most important part of this debate, and explain that Affirmative should win on players in and of themselves. As I flagged, I think that negative is just not especially certain in this debate about their victim of procedural justice. Like, on one hand, they're very concerned about false allegations, they're very concerned that people will lose their job when they should not, but then on the other hand, they're like quite keen to stand people down with no pay in some instances. I don't think they've provided a great deal of clarity about why clubs are likely to be good decision makers that do follow procedural fairness. We don't give you a series of reasons why actually discretion is worse for players in terms of fairness. Firstly, we explain that discretion invites clubs to make decisions about players' level of guilt, about the harm or the severity of the offence that they've done, and about the virtue of those players in and of themselves. Like, those are the metrics that we characterize right from first Affirmative that clubs are likely to employ when deciding whether or not they need to stand people down. And the explanation we give you there is that discretion is likely bad. It is likely something that prejudges people in society, in the media, perhaps even in the courtroom, as to the guilt of that player. Where clubs do decide to stand people down because the victim is sympathetic, because it seems like they really did it, that biases people against them, which I think is actually worse in terms of procedural fairness than anything proposed by Side Affirmative. And on the flip side, like as we tell you in terms of victims, where people are not stood down but did truly do it, this is something which seems to excuse them, either the thing they did or suggest that they did not do it at all. But additionally, we tell you that decisions are likely to be made in inconsistent ways because clubs are imperfect decision makers. That looks like, firstly, I think probably quite a bit of racism. We probably flip their minorities argument to explain that clubs are likely to be biased in who they think is likely to have committed a crime and therefore who they stand down. But we also explain that this just opens up a huge degree of leverage, I guess, for fans to lobby clubs to make it seem more appropriate, more appealing to stand particular people down over others. Finally, we just point out that this is a right routinely provided to employers in our society. Employers do not have to be in the courtroom, they do not have to be evidence gatherers, they do not have to be final decision makers, but they are allowed to produce contractual obligations to uphold the standards of behaviour and reputation of that organisation. So even if you believe this is a bit bad for these players, I think that this is probably just pretty principally justified on a procedural level. Finally, I just want to note that the argument we give you about discretion applies whether or not that club decides to stand you down, because the kind of media view or the kind of discussion, the kind of prejudgment we explain exists whether or not you're stood down. It is simply a matter of the process in and of itself, which means I think just on the practical impact, setting the principle aside, it's just pretty uncertain whether it's better for players to have their fans whipped into a frenzy, to have months of protracted media coverage, slander of their victim, their potential victim. I'm pretty uncertain that that is even better for them, particularly if Side Negative is standing them down with that. So if you believe players are the most important person in this debate and should do right by them, I just think it's side affirmative who provides you with the most consistent and least interventionist way of doing that. I'm now going to talk about victims, who we explain are the most important people in the debate. We explain positively from first affirmative that victims have experienced the highest scale of harm in many instances, and that they are particularly vulnerable, both by virtue of having been made a victim, but also because they just do not have the levels of support, the level of pay, the level of social esteem provided to elite sport players. And we explain that discretion produces an array of asymmetric harms for victims. It massively increases the level of attention that is provided to their case, but if it increases that level of attention in specific ways, that is to say, it increases the likelihood that people are talking about whether or not the club's discretionary decision was fair. It's, as they can see, it means that people are talking about whether or not that victim was sympathetic. And we explain that only occurs when you put power of discretion in the hands of the clubs. They have a series of responses. I want to start with the push that we get at second negating, which is, we can benefit victims by suspending people without pay. I think that is not better for victims for a few reasons. Firstly, and most importantly, I just think this is more likely to attract backlash. That is to say that a lot of the injustice that people are likely to feel outrage about and attack victims on behalf of the players for is the fact that they've lost their job, that they've lost pay, and that you feel bad for them. And I think that this also just makes clubs comparatively less likely to stand people down, because to the extent that clubs are a bit sexist, or a bit racist, or a bit homophobic, whatever the crime this person has done, they kind of sympathize with this guy. I think that they're far less likely to want to stand them down without pay because they feel a bit bad for the guy. Which means I think that you are just likely to get more people stood down on our side of the house, which on balance being comparative is better for victims. But I also just think you should weigh victims' interests. I don't think victims just want the maximally bad thing to happen to the offender. I think that they often care far more about their own privacy, about their own safety. The next thing they say is, well, it's not clubs' responsibilities to protect victims. I think that's not true. I do think there is a broad social responsibility that we all owe to people who have been at the receiving end of a terrible crime. But additionally, I would note that clubs take on a role in their community that is often about, setting examples. They often, for instance, try to have children's programs. They often trade in on their reputation in a really important way, which I do think produces, pretty significant obligations to be a good corporate citizen. But finally, as I flagged in my introduction, I don't think that negative is neutral. If they don't believe that it's clubs' responsibilities to protect victims, I'm not sure why they think it's clubs' responsibilities to ever take the side, then you should still vote side affirmative. The next thing they say is, well, sports clubs that actually, then they say, if the club doesn't do it, if they don't weigh in, then other people will do it. Other people will try and talk about whether or not this happened. So the clubs may as well do it to try and silence people. I think there's a couple of problems with this argument. Firstly, in another part of their case, they observe that clubs are particularly bad at discharging this duty. They explain that clubs are likely to be bad at selecting the kinds of victims, or we explain that clubs are likely to be bad at selecting the kinds of victims you can believe, and also that they're probably pretty poorly placed to explain themselves. I think for instance, a media event, I think a coach is relatively bad at explaining why a particular victim was believed over another, which means I just don't understand why it's better for the club to be the ones who get the final word on this. But I would note that I just don't think they are the final word on this. I think this is additive and multiplicative to discourse. It is not the final word, which means this is discussed in a specific context with a specific agenda that would not otherwise be. On that side, people are talking about this in the context of saying, is it fair that the club exercise their discretion in this way? Is this victim sufficiently sympathetic that we should decide, to stand this player down? I think that is quite clearly worse than people just generally talking about this in society. Then they try to mitigate the extent to which this occurs by saying, well, it's okay, we'd still be nice to sympathetic victims. I think this is the worst position in their case, because it concedes our argument about due process. And it's obviously hugely traumatic for victims to be at the whims of a sports club deciding if you're sufficiently sympathetic to be believed. Finally, they try to symmetricize the thing about trials. This is just not true. The more something is covered in the media, the more it's talked about on social media, the more that sports Twitters are tweeting about it, is more likely that you have a mistrial, more likely that a victim has to suffer through that, and less likely that people are willing to come forward at all. I think we take a very clear and straightforward win on victims. Finally, I just want to quickly talk about clubs. Rebutting the things about international laws, I think that this is probably pretty minor, very small volume of the crimes that are committed, but also you probably should follow local laws. I think players are reasonably incentivized to do so. But finally, I guess, I don't need to moral it, but I guess we just follow it if the state recognizes it as a crime. Obviously, if it's a crime that Australia doesn't recognize, Australian club probably wouldn't care about it. I just don't think this is very important. I would also flip the thing about liability and know that it is clearly better for clubs to have a clear policy that is in place of contracts, they're far more likely to get sued on site negative. And finally, I just want to, with our material providing a first affirmative to no response so far about other players, we explain that it is terrible for other players to share the court or the field with someone who they suspect might be a rapist. We explain that it is terrible for their reputation, that it leads to immediate furore around them. And if you believe that clubs have a duty of care to their players, it should apply to all their players, including the ones we talked to you about. God, crazy.
Panel, I think the fundamental issue in this debate is that on side affirmative, it removes the club's ability to actually advocate for the presumption of innocence, which I think is the most fundamental thing that underpins this debate. Now, we've talked a lot about victims, and I'm just going to start there because I think it's valuable, and I definitely agree that victims in this debate are the most important and are the most vulnerable. And on top of that, the government does have a principal obligation, like, to step in and like make an outcome on like certain things. However, that is not what this debate is about. It's not about what the government can do. Like, it's whether clubs or not should make this decision to like do this blanket ban, which is like directly against the presumption of innocence. Now, what I've got here is essentially just like one major clash, which is essentially, which is like the right between, you know, the presumption of innocence and the right to be believed, which I'll come back to more explicitly later. But then also like a key, you know, sort of idea issue through this debate, which is who gets to pass judgment. Now, starting off on that point, is that like, so what essentially here that has sort of come up throughout this debate is four actors essentially. And so firstly, the clubs, do they get to pass judgment? Secondly, the court of law, do they get to pass judgment? Thirdly, the court of public opinion, and then finally, of course, you know, police. So, bringing that down to firstly, the purpose of a club. Now, or really the obligations of the club. Now, Affirmative have said that like the club has two obligations to discharge. Firstly, to protect and relieve victims, and then secondly, to defend and consider the welfare of other players. Now, just on that first point regarding the overemphasis, regarding the believing the victims, I think first of all, we've got a bit of an overemphasis of like the club's discretion and their decisions, especially that impact showing up in the media in terms of like believing the victims. Like, yes, they should absolutely believe victims where possible, but they still need to have that discretion because unfortunately the matter is while it's a very minority case, it is a very serious thing to just like be like, oh yes, we believe you heart and soul when you've literally provided no substance. And then they've also backed that up in their own, Affirmative have also backed that up in their own substantive, saying that like, oh, the clubs don't get to talk to the victim, which is fair, and rightfully so. They also don't get to chat to the accused, which is again, rightfully so. So they're essentially being like, you need to, we should slap down every single case and deprive essentially the accused of a job in every single instance as soon as there's a charge laid against them, without any sort of evidence and any sort of autonomy to like make this decision. No, they don't get to make like the decision they don't get to. I think it's just like an overemphasis to say that these guys that the clubs have like this overemphasis on points. On the media, because the fundamental thing is, yes, the Affirmative team have brought up a great point of like, yes, there's a lot of mistrials because of media. We saw that recently with the in Australia with the Taav'n attempted murder case, where they actually had to do a bench trial instead of a jury because of all the media attention, and that would have risked mistrial. Now that is the media. Now. That is unfortunately the sports player being a victim in that one, but it's the fundamental issue is the media will report on the event regardless of whether like the club makes a decision or not in any direction. Like it's symmetric on both sides. It's non-existent on either side that like the clubs have that sway and that power to like their decision being such a big decision, because they do actually make these decisions quite consistently. They stood Israel Folau down. They stood several other people down that I can't name. So it's like, it's not to say that, yes, it's just essentially like, at no time has like the club's decision had like an adverse outcome on like the actual, on the media in of itself, because the media likes a good story, and sports players are celebrities nonetheless, they're going to get reported on nonetheless. So like this harm that they've pushed onto our side just simply doesn't exist in a bubble solely, and it's not solved by their case. Like it is going to be, this idea of mistrials is just like, it just doesn't exist. Now, coming back to the idea of like, defending and considering like the welfare of other players. Sure, I think this is a fair enough point where the crime in of itself is tangentially connected to the player of himself. Like, for example, there are plenty of players with driving under the influence charges. I think, and they aren't struck down. Why? Because that crime, while incredibly serious because it does risk the lives of every other person in the world who's on the road, but it doesn't directly impact the welfare and safety of other players. And that is like not up to the clubs to be like, okay, because you've risked the lives of other people, potentially risk the lives of other people in the world, you should then be deprived of your ability to have like meaningful employment. Now, in terms of like it's a right to be believed, yes. Again, this exists on our side of the house. Like the clubs can still believe, and like in fact, it's probably more meaningful for like the clubs to say like, yes, we believe you. Yes, we believe you, without just being ignored and just being like, well, yes, there's been an accusation. Like it's more meaningful to the victim and probably garners them more support on the positive. And then on the flip side of that, where like they're not believed, well, it's the unfortunate thing is like if it's getting to the point where like as they've sort of said in their first speaker, was like you have this incentive, they're less likely to come forward, victims won't come forward unless like it's a real and serious crime. Now, I think at the point at which like this is a real and serious crime, I think in their instance, the club does actually have that ability to be that actor. I just want to quickly touch on, just as a final sort of thought, is this idea of like procedural justice of and the accused being a victim of procedural justice. Now, they're, as a sports player, they are as a sports player, that is their job. So essentially, they should be subject to all, the benefits of workplace rights and investigations. So that includes, an investigation into the alleged crime and all of this, which means that without any of that, you are immediately subject to an unfair dismissal or a breach of their workplace rights and so on and so forth. So that is inherently them being a victim of procedural justice, and that was so
I think the opposition's second speaker is correct when they identify that what is truly at stake here is a conflict of rights. And the question is really, at the end of the day, do we value more the victim's supposed right to be believed in the public sphere, or do we value more an accused individual's right to the presumption of innocence? I think that's generally the core of tonight's debate. I think opposition has characterized this in a way that is largely uncontentious. I think they tell us, on the question of the victim's right to be believed, they tell you first that there is a charge laid, and that this means that the person is probably guilty. I think we respond to this in several ways. We told you first, there are some jurisdictional issues here. They characterize you that, these are high-level athletes that we're talking about in most cases. And then they say it doesn't actually matter where this debate occurs, or more importantly, where the charges lay. The charges are probably an indication of guilt. I think there's probably changes internationally and jurisdictionally, but regardless of that case, we also tell you that there are institutions that are suited to making decisions based on guilt and innocence, and there are institutions that are better built, better designed for this very purpose of conducting fact-finding missions, of finding the truth, of in some manner or form serving justice. They tell you, no, clubs have an equal obligation to serve justice, or at least to aid in the service of justice by other institutions. They tell you that the service of justice that is done by clubs is the mere act of standing a player down because this produces a fairer trial. This is their biggest benefit that they try to claim. But at the end of the day, their trials are more secure and more insulated. We told you media frenzy occurs on both sides. We told you media frenzy occurs especially because individuals who are at the whim of the public court of opinion are probably more likely than not in every instance to be the victim of the court of one half of the court of public opinion. We characterize several examples of this, but importantly, opposition never stands up here to tell you that the victim is more likely to be believed in the court of public opinion when the club is forced to stand the person down, right? They don't actually characterize that argument to you. And I think that for their case to stand, they really have to predicate it on this outcome being true. That is to say, at the point at which the person is charged with player, right? And the club is forced under their world to stand this person down with pay, under their world, they only get the benefits if it can be demonstrated that in the court of public opinion, people will start to believe the victim. I think they don't succeed in demonstrating this. But the reason they don't succeed is because all they manage to do is tell you that clubs are dangerous decision makers, that they have, incentives that are flippant, that lie, outside the realms of pursuit of justice. And while this may be true, I think we probably some compelling reasons why clubs should probably be trusted with decision-making processes that directly impact themselves, their players, and their employees. But importantly, they never actually tell us why the fact that a club, the claim that a club is a flippant decision-maker or a dangerous decision-maker, or is in some way imperfect and more liable to make terrible decisions, right? They never demonstrate why that directly leads to the harm being that directly leads to a less fair trial, because that is ultimately what the case is hinged upon, is deriving a less fair trial at the point at which clubs exercise this discretion. We articulate to you that there are cases where clubs' discretion is particularly important. We articulate to you that these clubs often have access to information that the court of public opinion does not, and there may be instances in which the club is making the correct decision. Or we articulated to you that there are instances when we use the content opposition tells you to say that victims should be credible. We tell you that at the point at which public reputation finds a victim credible, we trust that the incentive the club has to have a favourable public reputation aligns with them standing that player down in cases that will include without pay, or in other cases that will include with other conditions. I think that all of their content on danger to players on the field or danger to the community probably doesn't apply, because in the question of violent arrest, as Moni told you, this will in the question of violent crimes, that person will just not be out on bail probably. You probably trust the courts more to make that decision anyway than you do the club. You probably should for any reasons that they'll probably consider you in the first place. But I think largely because they've gone unable to prove that, just give us a little bit.
I want to start this reply by considering the negative team's case very generously. Their path to victory lies, I think, very heavily on this policy harming clubs. Charlie explains, and Third Negative unfortunately concedes, that we can fairly comfortably lose this issue and still win the debate, because the consideration of victims is a much more pressing one in terms of the ability to cushion harm, in terms of identity vulnerability, and in terms of the scale of harm. But for now, I'll consider their claims on face. They have two. The first is that this places a financial burden on clubs and that you could instead stand them down without pay. We explained there are a series of frictions to fire someone, their popularity, their relevance to the club, and helpfully First Negative adds one of their own, which is civil liability, which explains why there are very marginal cases where you don't fire, or where you do fire the person and you do stand them down in their world, which explains that the financial thing is already becoming pretty marginal. But I think civil liability, as acknowledged by First Negative, actually becomes a flip for us in this arena of debate. Because when clubs decide to adjudicate whether or not someone is actually guilty, they take on that responsibility themselves. They open themselves up to far more comparative liability. For the reason that in our world, it's a condition of your contract. If you commit a crime, you're charged with a crime, you're struck down. There's no grounds to get a civil liability in that case. But if it is in the contract that your employer has some discretion, you can argue that they can perfectly use that discretion, which explains why it is the case that they have some civil liability, which explains why actually the costs on the club of that increased liability are probably greater. But secondly, they say that clubs should be able to make decisions in their own interest, that they're intimately involved with the player, and that's probably in their best reputational and other interests. We explain 2 reasons why that's not true. The first is clubs tend to make decisions based on ascriptive characteristics like identity, like importance to the fan base, that are unlikely to be truly in the reputational interests of the club and its sponsors. That instead, what they should do, or should be mandated to do, is signal the seriousness of their values, which generally are don't commit crimes, which tend to harm their ability to retain sponsors and their reputation in the long term, which explains why even if they want to do something, they're not doing something in their interests, so they should probably follow our law. But I would also suggest one of the most important interests of a club is the safety of their employees. We explained right from my speech that the balance of probabilities is that this person who's charged on their club did a serious crime and they could do it again. Yes, they do a bunch of mitigation in the NAG block about, well, it's not relevant in every case, but that's not really touching the claim, which is, you're compelling employees to consent to an unsafety of some magnitude, and also defending someone that they may have issues with defending publicly, all of which is actually pretty harmful to the safety of your employees and probably overall for the performance of the club. So, the additional liability flips money for us in this debate, and even if it's not, it's pretty marginal and it's weighed off by both teams in this debate, and clubs make decisions that are not in their interests. I think this debate becomes much clearer on the consideration of victims. The first claim is that, well, you can do it without pay, but I actually don't think that's victims' priorities, and I also think arguing this creates tension in their case when they start to talk about the presumption of innocence. But the second way they try to get around victims is that there are other institutions to protect victims. But what they crucially miss in every speech is that they harm those institutions' ability to function, creating media furor and discourse that harms the ability to protect a presumption of innocence, that harms the ability for juries to access true evidence, that harms the ability of victims to be protected from vigilante justice. They contest the mechanism here by saying, well, all of these harms will happen anyway, by very nature of it being quite high profile, which is very weak mitigation, and this is the 2 aspects of our case where we make this asymmetric. The first is the nature of the discussion. In our world, it's, the question of the legitimacy of the case is far more deferred to courts. That is how it is framed by clubs. Well, whereas now, average people's estimations of who is guilty and who is not are far more in the discourse. But also, there are more moments of intrigue. Obviously, there's one exogenous one, which is the result of the trial. But they add another one, which is the club's decision about whether that person is guilty. When you go out to fill out your ballot, we've won the debate in 2 ways. First is by showing this is a policy in the reputational, financial, and safety interests of the clubs. But a second and much more emphatic way is harm that wishy-washy discretion reeks on victims who won't be prioritized by all accounts. For that reason, we vote
Yes.
Okay, thank you. Hi everyone, thank you all very much for the debate. Round 1 of Australs done. Great start by both teams. Good to get into it. Oh yeah, round of applause. I love a sports motion. I love a good sports debate, so I wasn't disappointed by today's debate. What we're going to do is some general feedback, announce the result, go through the reasons for the result. So, a couple of points of general feedback. I think the first one is both teams, I think, need to do a lot more work characterising what their world looks like. So, from what a no-fault policy actually looks like, how it's implemented, what crimes apply, how is it like a league setting, is it every club individually opting in, something more to describe what's actually going on. And simply from there, be a lot clearer on what you think your stance is that clubs should do and how they activate and use that stance. I think, obviously this feedback, I guess, really applies because this debate is to Australian teams, but the National Rugby League in Australia does have no-fault stand-down policy in place, so maybe we could draw a bit of inspiration from how that has actually played out. Obviously, with international judges and other teams, you have to explain what the NRL is and how it works, but I think with any sort of policy like this, where it is already happening in some sports, try and draw from where it's effective and why it's working there, or not working there in the case of the negative team. The second thing is I would have liked a bit more discussion around just how big the marginal difference or impact is going to be on some claims. I think the most pertinent example of this in the debate is the stuff around media coverage and the hype and attacking victims, questioning policies, etc. Because I'm willing to believe on both sides the media is going to act in a bad way and cause hype and do bad things to victims, prop up their own players, etc. But I want to hear a bit more about, if that's true, what is the actual difference we're talking about and why does that difference matter? Why does it flow on to the consequences that are actually likely to happen that both teams think? And the third part was, I think both teams need to engage more with just this question of like natural justice, procedural fairness in the debate. I thought this would be a much bigger thing, I guess, from both teams, defensively from AF, attacking from neg, as to this presumption of innocence. Are sports players entitled to that? Does this particular policy violate or not violate that? And that would open up a whole bigger area of principle law kind of element of the debate beyond just the sport element of the debate. In any case, so that it doesn't come up a huge part of this as an influence decision, but I think useful to think about for future debates. In terms of the result then, we both had the same decision and we awarded tonight's debate to Affirmative. Congratulations. There were, I think, 3 questions in this debate for me. The first one I want to look at is around victims. So Affirmative tells us right from the start that victims are particularly important and that clubs have particular obligation to try and believe victims because of their role in society, and a bunch of reasons as to why it is likely that victims are telling the truth, so therefore we are on their side. That being about how it takes a lot of time and money to sink into reporting these crimes. There's an incentive to attack victims, so it's a big risk you're putting yourself up for when you come forward. There's a lot of trauma involved in the process of cross-examination, media, police, etc. And also it's difficult to sustain a lie. So all those things kind of suggest therefore that victims are likely to be telling the truth in most of these cases. And then I think they give a second and third going on, that is a bunch of stuff about why victims in particular ought to be particularly prioritised. The level of vulnerability they are on their own, the comparative vulnerability versus sports clubs, sports players, etc., and also power imbalances that exist. So all that I think at this point is leading me to really believe the victims should be cared about. How does neg try and attack this? I think the first attack they give is that yes, we do care about victims. These are the wrong organisations making these decisions. There are other organisations out there that are qualified, experienced, and it's their job to advocate for and protect victims. I think this is all true, and we'll explain. I do think there probably are better organisations and clubs out there. However, I think as AF points out, that's not a reason to not have this obligation just here on clubs as well. So yes, victims get both those things, but if clubs can do this as well, that is still a good outcome for victims, and as we'll come to in other issues, probably a preferable thing to the other options that are available for victims. The second claim we get is that, well, there are some cases where there might be false accusations against victims, by false victims against players, and that is bad. I think it's weighing at second. It's particularly likely to be against minority players. I think the problem with this argument is it's a bit underexplained as to like why that would be the case and how likely that would be the case to outweigh all of this, but also particularly how the model shifts or changes that in any case. I think also AF is able to flip this claim by identifying that the more discretionary power you give clubs, that's when clubs have more power to act in those ways that attack minorities in ways that are unfair and more racist. So I think that the false accusation part I don't think gets up enough over the VIX. I think the third claim, I'll come to this a little bit more later on in the third issue, is one about like procedural fairness as a valuing point. I think a bit undercooked from next day as to why that might outweigh or should be considered the same as victims' rights in today's debate. So ultimately the first point about victims, I think we agree from AF, they should be doing stuff as clubs, they have an obligation to, and victims like are generally likely to be accurate in these cases. Let's then secondly look then at the second issue about whether or not clubs can actually use discretion in a way that is useful, because if they can't, then we should prioritise victims by doing this. If they can, then they can prioritise victims by doing it on next side. The first thing I know about this issue is I think that, sorry, I've already said that. The question is just who is more likely to use the discretion in ways that are effective. I think what third points out here from Affirmative very well is that there is a bit of a tension running through the next case about wanting to do two different things at times from the clubs. And sometimes we're talking about the clubs having all the expertise and evidence and knowledge to go harder than the policy says, to protect victims better by standing down with no pay and being harsher on them. But at other times they're saying that clubs shouldn't be making these decisions because it is unfair, because they do not have sufficient evidence, etc., to make these decisions as well. So I think there's a bit of contradiction here about exactly what we want these clubs to do, whether we want to protect the innocence of players, advocate for them, or whether we want to go harder. I think those things can be undone as a tension, but I don't think they are in the debate. It's makes it unclear about what we think clubs are actually doing with this discretion. What do we hear from what do we hear from neg here? So they declare that clubs should be able to make a decision about whether or not they see how serious this is. They know the players, they have more inside information about how likely it is to be true, etc. I think AF has a good response as to why clubs might not do this well. Is firstly on like a practical level, a lack of evidence, a lack of like know-how, etc. means they don't have full information to make a decision. But secondly, they're also likely to have particularly bad incentives in making a decision. Things around the quality of the players, loyalty to certain players, the optics, like who has a more sympathetic victim, etc. All these things are likely to play into how they make decisions, and those decisions are also massively influenced by how fans or media operate and pressure clubs to make decisions. That often today, both teams agree they're subject to some degree of financial pressure or pressure from fans. the more discretion they have, the more likely it's likely to be used badly in that case. So I think at this point then, at this part of the issue, I think that the way clubs are likely to use discretion is likely to be ways that are unfair and bad and do not help victims in some cases. The second push we get on clubs making decisions is, well, clubs have their own, need to protect themselves from civil liability, so we should let them make their own decisions, and that is the best one for them. I think, as firstly pointed out by AF, second, this is not relevant in lots of cases, it's just a contractual term that's put in place, so they can't sue for civil liability in lots of cases. But secondly, the issue of civil liability becomes worse when clubs are making determinations about what they think and using their discretion, whether they applied that fairly, what justice they used there, etc. Which I think all means that you get more variability with that discretion, which means more likely to have those issues of civil liability occurring on clubs. So I think they can, I think they actually open themselves up to worse outcomes on side negative on this point. The third point of response we get from negative is that it's an unfair thing on clubs to put this no fault stand down on them, because now the players are getting paid, but they're not playing, and they're not giving the money back. So on a transactional level, there's an unfulfillment of what the club is paying for there. I thought this was particularly interesting and a really good principle pushback as to maybe why clubs shouldn't be the ones forced to bear this burden. However, I think the problem is, I think, from negative, it just is, beyond pointing out that it might be unfair, it's about what to do with that in the debate. Why is that so much more important? What is significant harm here to clubs that should care about, etc. Which I think means it's hard for me to weigh this point as particularly important, especially when compared to all the way I've already gone through from around why victims ought to be more important. So yes, I think it might be unfair on clubs, but if we believe the Furness characterisation, these clubs are rich, wealthy, tens if not hundreds of millions of dollars of money involved, I'm not sure how big a harm that is. If I'm to step into feedback for a second, this policy probably also applies not just to like the big clubs, like AF is characterised, there's also small clubs that are a lot poorer who also have this policy operate, so maybe a bit of work from Neg to sort of move the debate to different characterisation might help make this point stronger, but I don't think that comes out, so it can't be credited. So back into decision rather than feedback, the next response we get from negative around decision making is, well, actually we want to go harder now. We want to have no pay for some of these players in some cases here, and that's how we better operate victims. I think obviously there's a contradiction that I talked about earlier, but I think as well from AF, they talk about how this policy might actually lead to a worse backlash from fans and from media, etc., which might lead to a worsening of those incentives to operate in bad ways on the club to protect certain players, depending on vulnerability and circumstance, not vulnerability, on optics and quality of player, etc. So I think what this leads to is the pushback from AF, having a blanket policy they can follow is a far preferable one than one in which they use at levels of discrepancy. The last, I think, smallest part of this question is one about international issues, like what if they have different standards in different countries, lots of leagues play overseas, etc. I think, as the third affirmative points out, these are likely to be quite a small group of issues compared to the majority of issues not having these cross-border issues, but also we should follow laws, we should still like face priorities, etc., and maybe just like punish crimes that are like are also a crime in both countries, or whatever the state requirement is for a crime. I don't think it's necessarily new modelling. I think it's a reasonable response, but also I don't think this issue is really, again, from Neg, built up as to being why this is the most important debate-winning clash. It should outweigh everything that's come before, so I don't think it's a huge lot of credit. I think we can resolve those issues in the small number of cases where they occur. So ultimately, this issue, we don't think clubs can make a great set of decisions when they have the power of discretion. The last question then becomes one more broadly about justice and how this policy impacts justice. I think AF gives us two big claims here. The first one is that this can have a lot of impact in the justice process. So the more, if a club makes a predetermination about whether or not this is a suspension worthy, is functionally a claim about whether or not they think this person is guilty or not guilty, can impact things about how the media responds to that. It will also be pressured by the media. That can flow on to things like juries or judges or court of public opinion, etc. I think a little bit more here on what we mean by court of public opinion, how that influences things, what the consequence of that is, and maybe a bit more about how it impacts jurors, particularly when this case would already likely be in the media anyway. I think there are a few hanging questions from AF that maybe reduce this impact a little bit, but I'm still willing to believe that somewhat there's going to be some sort of like extra step made which might influence some decisions. And the second claim we get on justice is a delegitimization one. So as clubs start to make normative judgments on what is serious and not serious, when people should or shouldn't be stood down, creates discursive impacts which hurts how people view players or view personal interactions. I don't think some of the more nuanced stuff or more impact stuff from AF gets a degree of response from negative. I think the most overall response we get to these issues is this claim is to attack the media mechanism, and that being that the media is all likely to be the same, beat up on both sides. And this is where I think Neg does a pretty good job mitigating here as to why the media would still have all the incentives to operate badly to quiz people. I do think AF is able to suggest that there is going to be this additive worsening when a club makes a determination in advance, which does add a bit more to it. So maybe it's not a wholly unique thing on AQUT, I think it does get a little bit worse. The second broad overall response we get to this with the negative is what I hinted at earlier, and that being about the presumption of innocence. And when we're talking about questions of justice, this is maybe what we should prioritise in this clash around like believing victims versus the protection of innocence for the accused. I think ultimately though this comes out a bit too late, has issues of contradiction, and is also particularly under-explained, which means it's hard for us to credit this as a strong enough principle to push back against those ways in which justice is already disrupted by having not having this policy in place, as Affirmative points out. And so for those three issues, AQUT ultimately takes the debate. But again, well done to both teams. Happy to give any feedback from both if you'd like them, otherwise well done. Good luck with Australs.